to our webinar on maximizing your military and veterans benefits. A few months ago, we actually had Michael into our office to work on our advisor education series and provide some insight into military and veterans benefits for our clients and for our advisors. So that was really the impetus today behind having Michael come and talk specifically to our clients and prospective clients. A little bit about Fort Pitt Capital Group. We're an investment management company. One thing that we do that's a bit unique than everyone else, we have in-house investment management. We're a very boutique feel, have a very dedicated client advisory team and client service feel. We're not limited to just investment management. We do financial planning, business consultation, 401k planning, and the crux of our financial planning is holistic. So in this case, if you're a veteran, active duty, retired military service member, taking into those considerations in a very transparent focus. We offer these webinars as a free service, and we're not just financial advisors. Again, we're life advisors looking at all the possible ramifications of anything in your life. We like to bring in outside specialists such as lawyers, accountants, healthcare professionals, business succession consultants. A little bit about me, Bryson Roof. I'm a certified financial planner. I've been doing this for over a decade. I really like to focus on veterans and military professionals. A lot of my family has been serving, whether it was my grandma during World War II to cousins in the global war on terror. My father-in-law was a Vietnam veteran. And actually, Michael and I talked about a lot of what veterans in Vietnam faced, and we'll be getting into that later today. Outside of work, I'm a huge dog lover. I breed AKC beagles and train beagles for field trial competitions. So if I'm not at work, I'm out in the woods with my dogs. And Mike, why don't I just open the door up and let you talk a little bit about yourself?
Thanks, Bryson. Well, thank you so much for having me today, and especially to everyone at Fort Pitt Capital. Just a little bit about myself. I'm an attorney, and our firm, the Quatrini Law Group, has been in existence for almost 40 years. Our main practice area, where we got our start and where we earned our reputation over time, was through workers' compensation and other injury or disability programs. Sooner or later, in July of 2008, the Veterans Administration, through statute passed by the U.S. Congress, allowed private attorneys to actually help veterans through the service-connected disability process. I was one of the first people in the country to get accredited by the VA to do this work, and I'm still one of the only people in Pennsylvania and across the nation that does this type of very specific disability work. We kind of, this dovetailed well with the work that we do, because what you find in Social Security disability is an administrative process, right? Step by step, having to prove that something happens. And on the workers' comp side, we have an administrative process, but we have to prove that an injury or disability came from something, an incident at work or vice versa. Well, the VA disability world is kind of a nice mesh of both of those things. And we get to use our expertise in the administrative process and our expertise of working with doctors and specialists to try to tie together the different things that happen to military veterans while they serve. Ultimately, we're going to talk through today about what the process looks like, specific presumptions that veterans are afforded depending on where they served, other ways to service connect things that aren't already on a list, and answer everyone's questions as to VA disability compensation benefits, whether you have them now or whether you're seeking them over time. So Bryson, again, thanks for having me here to talk a little bit about this. And again, the whole reason that you and I first talked was I see this as a huge advantage to veterans who are putting together their financial plans. Many times, those veterans don't realize that there is a stream of income, tax-free, sitting on the sidelines for a disease or an injury they may have sustained. There are also health insurance benefits for those, and sometimes spousal benefits. So that's why you and I started the conversation, to try to help the people that are already working with Fort Pitt Capital. But today I get to kind of tell this story to a broader audience, which I'm very grateful for.
And as we talked previously, a lot of times I think people have applied for benefits and were denied, and they've given up. And there's laws that have changed, there's regulations that have changed. So there are benefits available that we'll get into later in the presentation. Just a quick housekeeping item. We do have some handouts that we want to provide. You can, if you're using a phone, in the bottom right, you can hit your handouts. If you're using a computer, in the top left, you can click through and get to the handouts. And additionally, we do want you to ask questions throughout the presentation. So you'll see me looking between multiple screens. I'm fielding questions. When it comes to military and veteran benefits, it's been my experience that it's very situational. So if it's a very nuanced question, you'll likely get a follow-up rather than a dedicated question and answer on this webinar. But happy to field high-level questions while we go. And if you don't get the handouts and you have trouble with it, I can always email it to you, or Michael can always email it to you after the fact. So Michael, prior to the webinar, we had a lot of questions submitted, and there's a common theme among veterans saying, how do I get disability ratings increased, or how do I get access to benefits that I may not have known?
So let's start with what the process looks like, but let's even step back to how this benefit is connected to your service. What we are really asking for from the Veterans Administration is a monetary or medical benefit that is available for an injury, an illness, or even a pre-existing injury that was aggravated while you were in the military. This includes basic training. This includes active duty. This includes being overseas in theaters of war. This includes exposures at different bases, both stateside and beyond. So if there is something that happened to you while you were in the military, or you later found out that you were exposed to a particular tainted water, Agent Orange, radiation, the way to go about accessing these types of benefits is first applying with the Veterans Administration. Much like a Social Security disability application or an unemployment compensation application, you're going to be filling it out, telling the VA who you are, what your condition is, and frankly, where you treated and where you served. I always tell veterans, you don't have to have every specific date or specific time. You want to make sure you put as much on the application as you can. You want to follow it up with what's called a statement in support of your claim. Basically, your opportunity in your own words to explain the connection between your medical diagnosis and your military service. And then you hand that off to the VA. And the VA has what's called a duty to assist. They must help the veteran with their application. They can't just sit back and say, you know what, sorry, you have to prove everything to us. Once they get that application for benefits, they have to go and get service treatment records. They have to get potential exposure records. They have to get military records for medical treatment. They also have to get your medical records from the VA and potentially from any private doctors that you might see. Eventually, once they get all that information, they will then make a decision as to whether that particular injury or illness is in fact service connected, and they will issue a rating decision. This is a really, really important document because this is kind of what outlines what they are willing to pay for, what they're denying, and specifically how much they might pay for and why. It's also important because if there is a disagreement with that particular rating decision, that's when the clock starts to have to appeal it and argue that the VA made an improper decision either in denying it or in the severity of the way that the VA rated it. So let me give you an easy example. Let's say that while you were in the military, you sustained an injury to your left knee, be it in basic training or while you were active duty overseas. If you treated for that in sick bay, at a hospital, there should be some record of a left knee injury. You could apply for left knee injury. You could point out that it happened during even a approximate time frame. And the VA basically has to go and check your service treatment records, see that there was something there, and then determine, do you actually still have a knee injury that is related to that original injury, right? Let's give the easy example. You have that knee injury, and within months, within even a year of getting out of the military, you start treating for that left knee injury. There's something there that keeps it close to make sure that that connection looks like there's some continuity between the injury you sustained and the treatment and the symptoms you're having now. The harder case is you had that knee injury, but you don't start treating for it really until 30 years later. That's a harder connection to make. Does that mean you shouldn't apply for it? It doesn't. It just kind of outlines what the VA is trying to weigh in terms of what happened to you, the continuity of treatment to finally make that decision. Let's say they decide in that instance to rate it. Well, they have a big long chart in a big thick book that basically outlines all diagnoses related to the body and illnesses that list out, all right, here's the left knee. Is your knee this bad? You get this percentage. Is it this bad? You get this percentage. And it goes through assigning what is a percentage rating at the end of the day. Now, let's say they've made that decision to service connected and they only give you 10% disability rating for that knee, but they messed up and didn't realize that you also have a couple other problems with that knee that they missed. That is where you would want to challenge that rating decision. But that's kind of a basic example of how you apply, the way that it could be potentially connected, the rating you might get, and ultimately the process by which you would disagree with that percentage at the end of the day. So, Bryson, just to kind of kick it back to you for a second, in terms of these rating decisions that people receive, I want everyone to know, and your clients to know, that they only have 1 year to challenge that rating decision. I'm sure that there have been clients that you have worked with that have come to you and said, look, I did apply years ago. It's been more than a year. I guess there's nothing to do with it. Have you heard that before?
Actually, we just heard it through a type-in question. So why don't we address that?
So, I mean, this is not my first rodeo. I love tossing up good questions like that. So basically, this is a question I get all of the time. And am I out of luck because I didn't appeal it within that year? The answer to that is no. And that's important because the VA of 30, 40, or even 20 years ago, it was a different animal than it is today. And I say that in the sense that culture at the VA of deny, deny, deny for a very, very long time. And so someone that might have applied for something in the 60s, 70s, 80s, even early 90s, they were treated a little bit differently, I think, than the way that the VA is processing these claims and giving the benefit of the doubt to the veterans nowadays. The other thing that has changed is that the VA has opened up and said, you know what, turns out there were a lot of bad things that happened that we are now willing to admit. Some of those include the water at Camp Lejeune, additional Agent Orange claims, and everything else. So what do you do in a scenario like that? Let's say that you were denied on July 10th, 2012. And you didn't do anything within a year. As long as you have new and relevant medical treatment that the VA had not previously looked at, you can file what's called a supplemental claim to reopen and ask the VA to look at that case again. Now, new and relevant evidence is a pretty low barrier, meaning as long as it is medical evidence related to the diagnosis that you're asking them to review that they previously had, that's enough. You can't just simply say, you know what, I want you to take a look at it again. The only time you could do that is if you applied for, let's say, something that was related to Agent Orange. It's called heart disease. You did that in 2001, and you were denied because it wasn't currently on the list of Agent Orange diagnoses. But now it is. In that instance, you can ask the VA to take a look at that again because the law changed to add ischemic heart disease and coronary artery disease is one of the presumptive claims under Agent Orange. So write this down. It's in your materials. A supplemental claim application is the document that you would want to use to reopen that previous denial and ask the VA to take a new, fresh look. But just remember, you have to have that new and relevant evidence that you can point to, be it through VA treatment or treatment through your private doctor at the end of the day.
So Michael, what would happen if you applied for Agent Orange and you were on a ship outside of Vietnam and they said you didn't have boots on the ground?
Good job, Bryson. You read my materials, so you get an A for the day. So
Actually,
that's one of the things. Yeah, so that's one of the things that is important to understand. And, you know, it's opportunities like this that I get to tell as many people in Western Pennsylvania, which is a huge area of veterans within the United States, of changes in the law that could ultimately affect their benefits. So prior to 2020, anyone who was on a Navy ship that served during the Vietnam War, unless you put boots on the ground, you were not deemed exposed to Agent Orange. And why did I use boots on the ground in the first place? Well, prior to the 1990s and early 2000s, the VA used to make you, the veteran, prove that you were exposed to Agent Orange. Well, no offense, but that was 30 years, 40 years prior to people being in Vietnam. And it was impossible for Vietnam veterans to say that I was in this exact location on this exact day, and they were spraying that particular day. Well, that finally reached a fever pitch, and Congress eventually stepped in and said, you know what, time out. Here's the new rule. If you were on the ground with a boot at any point in time between this date and this date, you were exposed to Agent Orange. We are not going to fight that fight anymore. And because we presume that you were exposed to Agent Orange, if you have this list of diseases, we are going to pay you benefits, right? That's what we call presumptive conditions. You were in a certain place during a certain time, Vietnam. We're going to talk about Camp Lejeune, places in Gulf War, and you have this list, any of these diseases on this list, you are automatically going to sail through the process and be service connected for those things. Still might have a fight as to the percentage that you may get, but ultimately those should be smooth claims. One of the instances that Bryson just came up with was there was a case that was decided in the federal circuit courts that basically said, all right, for those people on Navy ships, if your ship was within 12 miles of the coastline and landmass of Vietnam, you are now deemed exposed to Agent Orange. Think about that, right? No longer was it just a boot on the ground. It's now anyone that was within 12 miles of the landmass of Vietnam. That opened up tens of thousands, probably hundreds of thousands of claims for Navy veterans who previously had applied for Agent Orange related diseases that they had, but they couldn't meet the boot on the ground requirement. So here's an instance in which if you were on that Navy ship and you previously applied for that condition but were denied because you weren't exposed to Agent Orange, now's the time to ask the VA through that supplemental claim process to take a new, fresh look at your claim. Even more recently, under what's known as the PACT Act, P-A-C-T, the U.S. Congress and VA are now recognizing that if you were on any Royal Thai military base, you are now deemed exposed to Agent Orange. Again, opening up avenues for hundreds of thousands of veterans who had been fighting to prove that they were exposed to Agent Orange while being in Thailand. That now becomes a much easier road because it falls under the presumptive qualities. This also includes Guam between 1962 and 1980 and parts of Cambodia during that time as well. Separate and apart from just the Agent Orange exposure, Bryson, they've also added additional medical conditions over time. This happens every few years now. So most recently, within the last couple of years, they added bladder cancer, hypothyroidism, and Parkinson's-like syndrome. Why is that important? Parkinson's disease is already an Agent Orange connected condition, but there were a number of veterans that were exhibiting symptoms that were similar to Parkinson's disease, but didn't exactly have the Parkinson's diagnosis. And so now they've opened up that door that if somebody is diagnosed with Parkinson's plus, Parkinson's-like syndrome, that is now an Agent Orange condition. More recently than even that, hypertension was added on top of the ischemic heart disease and coronary artery disease that was added a few years ago, and a diagnosis of what is called MGUS. So the lesson today is if you were previously denied for being exposed to Agent Orange and you were in Thailand on a Navy ship or other parts that I listed, you need to reapply. If you previously applied for these conditions that I just listed today, they've now been added to the Agent Orange list. You should reopen those old claims.
What about Camp Lejeune? What about Desert Storm? We have a lot of veterans on the registration list that have had some questions about that, where they say, I've only been in for 4 years, I don't have a retirement, am I still eligible for benefits?
Anytime that you have active duty service and you were either injured or exposed to something during that active duty service, it doesn't matter how long you were in the military. The most important thing is that you don't have a dishonorable discharge. As long as you have an honorable or even a other than honorable discharge at times, but let's just stay with the honorable discharge scenarios, that's enough for you to be able to apply for service-connected benefits. There are individuals that I've represented who sustained traumatic brain injuries when they were in basic training, meaning they were only there for a month, 2 months max. That is still a service-connected disability situation. Here's another kind of wild thing that people don't know. If you are active duty and you are home on leave and you are injured during that leave in a car accident, in a fall down the steps, you are still considered active duty for the purposes of service-connected disability compensation as well. So a lot of people will think that, I was home, I was in a motor vehicle accident during my leave. How could that potentially apply? You still fall under the active duty scenario for those types of benefits. So moving on to your other question about Camp Lejeune, I don't know if you've seen one of the 17 million ads on TV, on the radio, text messages, every single day about Camp Lejeune and the tainted water. Well, here's your 1-minute explanation of what has been going on. Camp Lejeune water was contaminated with caustic chemicals for a 40-year time frame. And it wasn't until recently that the VA was willing to acknowledge not only that it was caustic chemical in that particular water, but also to push benefits available, much like the Agent Orange presumptions, for anyone that served more than 30 days at Camp Lejeune. That has been a service connected within the VA process since at least March of 2017. I had actually been doing cases all the way back into 2010 for those particular water cases. But as of March of 2017, they became presumptions. There is a list of diseases that if you are afflicted by, much like Agent Orange, as long as you can prove that you were there for more than 30 days, and you have this condition, you can automatically get paid. Even if you have another condition that isn't on that list, you still have the opportunity, much like Agent Orange, to prove that your condition is as likely as not related to that exposure at the end of the day. Why do I say that? A lot of veterans say, well, I was there, I know that I was exposed, but I don't have one of the cancers that is on the list for either Camp Lejeune, Agent Orange, or maybe some other exposure. Well, that doesn't mean that you can't still prove your case. It's just a little bit harder. But at the end of the day, we've been able to prove that additional cancers were related to Agent Orange. Additional cancers were related to Camp Lejeune water by having their medical professionals say, based on their medical expertise, that these conditions are as likely as not. That is a fancy legal term for 50-50, okay? So it's as likely as not. As long as we can get to 50-50, the VA gives the presumption and the benefit of the doubt to the veteran at the end of the day. So it's just something very important to remember, is that it's not just a list of diseases, it's the other things as well that come from your service that can still be connected. Well, a number of those Camp Lejeune cases have now been, have gone through the system. They've been adjudicated. I've been a part of proving that there are additional cancers or wrong percentages at the end of the day. But in August of 2022, Congress passed the Camp Lejeune Justice Act, right? Prior to that, you had really never seen anyone broadcasting Camp Lejeune cases. Well, what that act did was it created a separate lawsuit that veterans, their spouses, or their children could file against the federal government in federal court, much like a lawsuit would be filed here in state court for an injury that may have occurred, a tort action, we call them. And so because of that, you saw all of these nationwide class action firms decide, holy cow, there are going to be about 1.5 million plaintiffs available. We are going to try to scoop up as much of these people as possible, and then we'll figure out kind of how to go through this class action in the next couple of years. So there were people like me that were sitting back saying, Camp Lejeune, this has been around for a long time. Where did all these people come from? Well, because of this other right of action that it was created by Congress in August of 22, there's now a separate lawsuit that is possible. Now, people have signed up. People thought they were going to get their checks in about 2 weeks. Turns out that the process by which this entire thing is going to happen is only going to happen in one federal court on the eastern part of North Carolina, and they still haven't written the regulations for it yet. And so you have a lot of veterans that are sitting out there expecting that things have been filed, that things will be moving quickly, that I'm here to try to provide some caution to people that A, this is going to take a very long time, and B, one of the things that I've cautioned some veterans about is if you do or potentially get any money from those particular lawsuits, it may affect your VA disability benefit that you're already getting for Camp Lejeune at the end of the day. So it's really going to take a long conversation. Good news, I'm here to have that conversation if you want to call me, as to what avenues may be best and kind of the caution of who to hire at the end of the day. I will tell you that my office is not doing those claims because they're based in North Carolina, but we have now figured out who is doing them, who are Pennsylvania based, and the people that can kind of be trusted not to ship you out to another law firm. So those are the Camp Lejeune cases. If you are a Camp Lejeune veteran, you were there for more than 30 days, you fall under this presumption. You may also have a right of action under this separate pact, Camp Lejeune Justice Act at the end of the day.
So Michael, I know we're talking a lot about veteran benefits based on exposure during their service. Some people have questions about, well, what about if I'm active duty? What if I'm going into a nursing home? Are there benefits there? And part of our financial planning process is that we cover a lot of active duty military members and how to use the retirement system, making sure that we're getting the TSP matching. How do we use the retention bonus in an effective manner? And how do we take advantage of maybe an early lump sum distribution prior to retirement? And that really comes into our financial planning process, but that's when we uncover a lot of the questions about nursing homes. And I know that's not specific to your practice, but we do have, and it's important to note, other attorneys that work with getting VA benefits when they go into a nursing home. So that's kind of how we handle those situations. Another question I had was about Desert Storm. Do you have anything that you want to discuss about service-related items in Desert Storm?
Yeah, so, much like Agent Orange took a long time to acknowledge, much like Camp Lejeune took a long time to acknowledge, well, here we are with Gulf War veterans finally being given that acknowledgement, right? You've heard stories on TV, you've read articles online about burn pits, about different types of exposures that Gulf War veterans had to deal with over time. And luckily, in August of 2022, there have been a lot more conditions that the VA has acknowledged are presumptively related to Gulf War service. So on that list, which I've included in my presentation that I provided to everyone, there are a number of cancers that are automatically presumptively connected to Gulf War service. Equally important to that, and something that affects more people than cancer on a daily basis, they've also confirmed that asthma is on that list. Chronic bronchitis is on that list. COPD is on that list. Different types of chronic allergies are on that list. That's important because there are also secondary conditions that come from that, right? If you have chronic asthma, even if you have chronic rhinitis or sinusitis, that can lead to sleep apnea over time. And for that becomes a secondary condition for the first one, which is a good opportunity for me to talk a little bit about how secondary conditions are related and paid similar to primary conditions. Let's use the easiest one of them all, diabetes. You're a Vietnam veteran, Agent Orange exposed, diabetes is on the list of automatic presumption. What comes from diabetes over time? You can start to have peripheral neuropathy in your lower extremities, peripheral neuropathy in your upper extremities. You can start to have problems with your eyes over time. Because that initial condition is service connected and caused the peripheral neuropathy over time, you can ask the VA to service connect your peripheral neuropathy, your eye problems, other things that may be related to that primary diagnosis. So let's go back to the Gulf War again, right? I just talked about having long-term asthma, problems breathing over time that eventually can lead to sleep apnea. You can then ask the VA to service connect you for sleep apnea secondary to your long-term breathing problems as well. Sometimes that sleep apnea can lead to insomnia. It can lead to anxiety over time. Those can also be secondary conditions at the end of the day. And so Gulf War has now opened up in terms of presumptive conditions because of the burn pits, because of the other exposures, much in the way that Camp Lejeune and much in the way that Agent Orange has been recognized over time.
We had a couple of people who said that they were atomic war veterans, which is a much smaller group, atomic war veterans. And I know that there's different payouts. And one thing that we look at, there's an option to select between a lump sum and a lifetime payout. So based on health and life expectancy, we actually run the calculations with them to help them determine, does it make sense to take that lump sum? Does it make sense to take a lifetime payout? Is there anything on your end? I know that's an inquiry that just came in. We didn't plan on this one in advance, but anything on atomic war veterans that you've had experience with?
It's a pretty rare group. But let me take this opportunity to say this. In terms of those benefits and planning, VA service-connected compensation payments, they're tax-free, right? There are some veterans that I represent who are still working full-time, and they're getting $500 a month, $1,500 a month, all the way up to $3,800 tax-free a month because of the recognition of their service-connected condition. I think that's important as an added benefit. We try to look at all of our Social Security or workers' comp or personal injury clients just to see if there's any little additional thing that we can get them on a monthly basis. That also can increase if you have a spouse or a child. And ultimately, if that individual is service connected, let's say for a cancer or a very serious condition like a heart disease, and they eventually die because of that service connected condition, that also opens up the opportunity for their dependent spouse to apply for what's called dependency and indemnity compensation. Basically, what you are saying to the VA is the service connected condition caused the death of my spouse, and because of that, I should be entitled to a monthly tax-free benefit. And so again, when planning, having the knowledge that this individual is service connected for a particular condition, if they do pass away, having the knowledge to say, hey, wait a minute, this person had a heart attack and they died, but they were service connected for that heart condition. You, spouse, should be entitled to apply for that type of benefit. That's separate and apart from what you brought up earlier in terms of nursing home care. There is something called aid and attendance benefit. Basically, that if an individual requires the aid and attendance of either their spouse or professional in-home care, or having to go to a nursing facility because of their service-connected conditions, the individual can apply for aid and attendance benefits, which could be payable on top of the service-connected benefit to offset the cost of that institutional care, the care that's coming into the home, or even the care that the spouse is giving, assuming that they may have had to leave their job or something else. So not necessarily on topic of the atomic veterans. I think it's a deeper conversation that has to be kind of specific one-on-one, but it's just in terms of understanding when to take those payouts, how to think about service-connected disability compensation and what role it plays in people's overall financial planning. I think it's just important to understand that not only is it tax-free, but it can be a benefit for a spouse upon death. It could be an additional benefit if the person requires that aid and attendance, both in-home or out of their own home.
I think it's really important to factor that into the long-term financial plan because it is a pretty significant benefit in many cases. So,
and I will say this, it's something that everyone should be asking, not only themselves, they should be asking their friends and family if they serve, because they may be shocked to realize that they may be entitled to a benefit. And while they may not be getting a lot of money now, a lot of these conditions get worse over time. They require maybe a surgery. They require very expensive medication. Well, if you're service connected for a condition, your medication for that condition is free. Your surgery is free through the Veterans Administration. Those kind of costs can add up over time. And so it's important, I think, for young veterans to try to get those service connected things on paper, service connected early, just so that long term, as they may or may not get worse, you can ask for that increase. Or if it eventually prevents you from working on a full or part-time basis, you can actually ask the Veterans Administration to pay you what's called individual unemployability. So in that scenario, separate and apart from Social Security disability, where I'm basically saying I can't work on a full-time basis, there is a separate program through the Veterans Administration that if your service-connected conditions are preventing you from working in a full or part-time basis, even if I'm not 100% disabled on paper, if they determine that that is the case, I then get paid at the 100% benefit level because I'm unable to work. And basically the service-connected conditions took that away from me. And that could be a powerful, powerful benefit for individuals, not only that may be applying or being paid Social Security disability, but it can really be kind of that income loss stream if their conditions are now preventing them from working the thing that they knew, the thing that they loved, that they kind of kept holding on to, that it was eventually taken away from them.
I think one thing that I'm getting some questions on is about hearing loss. And some people are talking about 3M, some people are just talking about service-related hearing loss. I think in my practice, what I've noticed with clients later in life, they're holding off, they don't want to get hearing aids because of the cost. And if I find out they're a veteran and I refer them to the VA, why don't you walk through that process and some of the cost savings that can occur by doing that?
Yeah, it's important to note that for hearing loss and tinnitus, which is the fancy legal or medical term for ringing in the ears, tinnitus is actually the #1 claimed condition throughout the entire VA process. The Undersecretary of VA Affairs just told me that at a conference 3 weeks ago. There are millions of claims that come out of that. And I will actually tell you they're pretty generous with tinnitus and veterans, especially if it is quickly confirmed that you saw any type of active military warfare, or depending on what your job was in the military, they'll connect you for that ringing in the ears pretty quickly. They also may service connect you for hearing loss, but basically what the evidence has to show is you had a hearing test when you went in, and that the hearing test that you got on your way out of the military, that there was a shift in your hearing during that time frame, and that shift was permanent in nature. Not to say that those are kind of hard claims if they are many, many years later, but they just get a lot harder if they're attenuated 20, 30 years from that noise exposure that you may have had, especially if there were intervening things like you worked in a steel mill or you were around heavy construction equipment. That can kind of really gum up those types of cases. But even separate and apart from the service connection side, the VA is willing to offer hearing aids separate and apart from service connection at the end of the day for low cost or free. And so I actually get a lot of calls where the person will say, well, the VA gave me hearing aids, so I must be service connected for hearing loss. Should I file a claim? I typically tell them, you're lucky that you got the hearing aids. It doesn't necessarily mean that they're going to pay you benefits at the end of the day. Doesn't mean you shouldn't apply, but to your point, hearing aids are much more readily available and much more affordable from the VA. So much like you, I always tell clients that I have to start there first before going and purchasing them over the counter or anything like that. And just to touch on the 3M thing. So just to give everyone a little bit of a background, basically what happened was 3M, the big chemical supplier, used to produce all of the hearing aids that were given to active duty military for, let's call it a decade, maybe even longer. What came out later that those hearing aids, those hearing protection, the little things that you put in your ear, either foam or the other ones, they were defective. And so there was a separate class action lawsuit that veterans could jump into, separate and apart from the hearing loss claim that they could file under the VA disability compensation system. I'm here to tell you that those claims are still going on. However, I will caution, I think the time to get into those claims may have, pretty sure has already come and gone. I believe there was a deadline to get into that class action lawsuit, and it may have been a few years ago. But if you are still curious about that, I can at least connect you with someone that is in that lawsuit to tell you whether it's too late to jump in or not.
Is there anything that you would like to wrap up with and kind of give a quick summation of what we talked about today. It's kind of the highest takeaway for veterans who have served and don't know where to proceed if they're having some health issues or if they're trying to claim benefits.
Yeah, I think one of the things that I try to drive home to anyone I talk to is if you're not treating for something, you really can't apply for it, right? There are a lot of times where someone will say to me, I have this problem, right? I hurt my foot in the military. And I'll say, when was the last time you treated for it? Well, I haven't treated for it. I've just dealt with it forever. Well, even if there is some indication in the military record that you did have that foot strain, a break, or something else, if there's not current medical treatment for that diagnosis, well, the VA just essentially acts like it doesn't exist. That's equally important for someone who's already service connected for a condition that's getting worse, right? Let's say you did get 10% for that knee or a shoulder or a mental health condition like PTSD, but it's gotten worse over time. To be able to substantiate that request for an increase, you really have to have some medical treatment, I think, to be able to go to the VA and say, hey, look, that knee problem I had, I'm now here, I'm going to require surgery. I'd like to look at an increase for that particular benefit. Or I'm now having surgery scheduled next Tuesday for that benefit, or I had it last Thursday for that service-connected knee. You can ask the VA for a temporary increase to 100% for the month of your surgery and potentially some months after if you require additional convalescence. Basically, that's the VA saying, look, we assume that you're not going to be able to work for that particular month, maybe a couple months afterwards. We should bump you up to that full amount for that surgery that you had to undergo at the end of the day. So I think it's just important that treating for your condition, right? I say this in Social Security disability as well. The legal world just assumes that if you go to the doctor for something, it either doesn't exist or it's not that bad. And not to say that I'm telling everyone to run off to the doctor every time you have an ache or something like that, but it's important that you tell your doctor so they can treat you for it. But it's equally important that once that document gets written, that it's something that the VA could read to be able to decipher whether your condition has gotten worse, whether there is a connection at the end of the day, so on and so forth. So treating for those medical problems are really important. The other thing I will always caution a little bit is that let's say you are looking for an increase in one of your conditions. The VA does have the opportunity upon asking for more money for a condition to send you for what's called a compensation and pension exam and then say, oh, actually, not only do we think that that condition didn't get worse, we actually think you got better. And so now we're going to take that 40% you're getting for something and we're going to bump it down to 20 or bump it down to 10. So I always tell people, if you're not treating for something and there's really good concrete evidence that a condition has gotten worse, meaning you've been hospitalized, you've been seeing an orthopedic surgeon for that knee, you're for that mental health diagnosis, and it's pretty clear in those records that it's gotten worse, you have to be a little bit careful of asking for that increase, because I'd say in the mental health side of things, in the back and cervical neck percentages, sometimes it can get a little dicey that when you go in for that C&P exam, somehow, somewhere, some doctor thinks that you got a little bit better. Could be a nurse practitioner that you're seeing for one of those appointments as well that isn't as schooled in VA disability law as maybe some of the older nurse practitioners that might have been there. In that particular instance, they can lower your percentage, which can then cause quite a bit of panic. Those are cases that I do all the time, unfortunately, but that's what I think I would leave everyone with is a couple of things. One, if you think there is something that you are service connected for, and even if it's not on the list, you should apply for that benefit because the VA has to examine whether that is the case. If you are service connected, you have to really figure out whether that percentage assigned is correct at the end of the day. And ultimately, treating for these conditions is really going to be the best support, the best tool that I have at the end of the day for being able to take these cases on. I will also just say that private medical treatment outside the VA is important. I think it's one of the things that we've done really well over the years is that VA doctors will not provide opinions for you that something is service connected or that it got worse. But our ability to connect that person with a neurologist, an orthopedic surgeon, a neurosurgeon, to really get a good assessment of how bad their problem is or how severe it is really part of the magic to be able to say, see, the VA is really not doing a good job of this. Here's the private medical report that really confirms, based on an MRI that they just had, that their condition is worse, or it's not, it's worse than what you rated it at the end of the day. So I always take the time, if people have these questions as to what they should do, I always encourage people to call me. I'm happy to sit and talk with them on the phone for 30 minutes to say, look, here's a strategy. If you want to go after something, I would do these things first, or nope, I'd go get that application filed as soon as possible. I'm always willing to talk about those two things at the end of the day, just so that people have a better understanding of what they're going after and how to do it.
Mike, what would you say for clients who have children that are currently serving, whether it's active duty, AGR, or reservists? How do you document these service-related injuries, exposures, while they're still serving?
I think it's one of the hardest things for active military to do, because I'm pretty sure we all know that there's a culture of toughness in the military, right? Don't just run off to a doctor every time that you get hurt. But it's that toughness that can really harm you in the end, because something doesn't get down on paper. So I will tell people, treatment, treatment, treatment. It's really important to get that on paper if something happened. It's no different than a work injury, reporting it immediately at the end of the day, if we think we're going to be successful in tying that work injury into something that they're diagnosed with. So I would say treatment is 100%, reporting it is 100%. Sometimes what I will also say to people, and I think I encourage them to do this, is that when they're home on leave, or if they have access to medical treatment outside of their military base that they're currently serving on, go put it down on paper, right? Go see a doctor, your PCP, an orthopedic surgeon, a specialist. Do it outside of the military so that there is some contemporaneous reporting, treatment, and diagnosis for that condition, so that a year, 5 years, or 10 years later, we can point back and say, okay, look, this person happened to be in the middle of a firefight. I don't know if you know this, but there's not like a UPMC urgent care somewhere when, and you say, like, let's stop the fighting, I have to go over here. That happens all the time. Stuff doesn't get reported. It makes sense. But quickly after getting back, either reporting it to the military or going and get some private medical treatment. I've won cases where an individual went to a chiropractor when they came home for that back injury, and they described what happened to them in the military. They went to see their PCP and they reported that they had a concussion in the military and reported their symptoms. Getting it on paper, even outside in a private medical facility, sometimes that takes the weirdness of reporting it within the military structure. It's a way to do it, put it down on paper without having to face the, oh my gosh, I can't believe you're reporting this. Are you not that tough kind of person? So that is, I think, my best advice is treatment, treatment, treatment. Even if it has to be outside of the military structure, it sets that target and it sets that diagnosis then.
That's great advice for kids right in high school. Their parents are talking to us. We can share that. So I appreciate that.
Sure.
So we're kind of wrapping up on time. Just wanted to thank everyone for joining us. I want to thank you, Michael, for being here. Again, we have the handouts in the presentation. If you're having challenges getting them, please shoot me an email. Michael's happy to follow up with you directly as well. We did not hit a lot of the very specific retirement questions that are very unique and individualized to each person. We do work with clients that are in the gray zone for reservist pay and how to maximize that. So happy to have a one-on-one dialogue regarding that. But any type of question you have when it comes to retirement, military benefits, veteran benefits. We're always happy to be the first place to go. If it's a family member, if it's a friend, happy just to have that initial dialogue. So thank you very much for attending. Our upcoming webinar, we have a colleague of mine, Brad Newman and Miles Clements. They're going all over about insurance. So please tune in June 28th for that. And thank you so much. And we look forward to talking to you.